Good morning. We're going to go ahead and look at the judicial process matching activity. So we'll just go through each one of them, make sure you're on the right page. So the first one is bail. That is N, the amount of money put up by defendants to ensure their return to court. So this is not a get out of jail free card. This is an amount of money that is determined by the court that a defendant would pay in order to go home and await trial there rather than waiting trial in jail. It is not a get out of jail free card. It is essentially just an assurance that somebody will return. Number 2, bail bond company is M. It employs bounty hunters to track down defendants who do not show up to court. So if you do not show up for your trial, there is recourse to try to get you there. Number 3, Bail Reform Act is L. Permits keeping defendants charged with federal, violent, or drug charges from getting bail. So there are certain federal crimes that you can commit that would make you ineligible to receive bail. Number 4 is booking, and this is C, the formal process of making a police record of an arrest. So this is when you are photographed, fingerprinted, and there is that formal record of the arrest that is made. Number 5, excessive bail is G, prohibited by the 8th Amendment. So the 8th Amendment prohibits excessive bail, excessive fines, and cruel and unusual punishment. Number 6, exclusionary rule is S. You have to go to the next page for that. A principle that prohibits the use of illegally obtained evidence to find the defendant guilty at trial. So if something was obtained illegally by the police, it cannot be used in a trial. It is inadmissible. You can still take that person to trial, but you can't use that evidence. Number 7, felony arraignment. That is P, a court hearing in which an alleged felon is required to enter a plea of guilty or not guilty. Now, those aren't the only pleas that somebody can enter. However, those are the two most common. Number 8, good faith exception is K. It permits the use of illegally obtained evidence when police relied on a warrant later determined to be invalid. Essentially meaning that if when police conducted some sort of search, they believed that their warrant was valid, they believed that it was not flawed, that evidence can still be used. So if it was missing a signature, if the date was filed incorrectly, if there was some other type of clerical error, it can still be used in a court of law because the police believed that it was indeed valid. Number 9, grand jury is D. A group of people charged with deciding whether there is sufficient evidence to believe that a person committed a crime and should be charged. So a grand jury is used by many jurisdictions to determine, especially in serious felony trials, whether or not a trial can actually proceed. Number 10 is a guilty plea, and that is R. Before accepting this, a judge must verify that it was made freely, voluntarily, and with knowledge of the facts. Obviously, we want anybody who is entering into a guilty plea to do so with full knowledge of what it means. Number 11 is indictment, and that is Q, a formal charge of a criminal action in federal cases. So it happens after the arrest, and when somebody is formally indicted on a charge, that means that they are proceeding to trial on that charge. Number 12, information. It is a formal misdemeanor charge filed with the court. We'll talk more about that later. Next is initial appearance, and that is T. Court hearing in which a magistrate, who is just another word for a judge, informs defendants of their rights, states the exact nature of the charges, appoints an attorney, or gives the defendants an opportunity to get one. So this is not the trial itself. This is not even entering a plea. It is just a matter of providing the defendant with the ability to find representation for him or herself, and to have all of the information provided to them. Number 14, judicial integrity. It is an argument that supports the exclusionary rule. So the exclusionary rule states that any illegally obtained evidence cannot be used at trial. That is in order to preserve judicial integrity and to preserve the integrity of the courts, the respect of the courts. 15, motion to suppress evidence is H, request to the court to keep out certain evidence from a trial. So maybe the defense wants something to be not included because it was obtained illegally, or it was more prejudicial than probative, basically meaning that the value of the evidence is only meant to try to sway the jury, and it doesn't have any actual real value. So, lots of reasons why somebody will want to suppress evidence. 16. Nolo contendere. It is a type of guilty plea in which the defendant does not contest the charges. So they do not admit guilt, so they're not pleading guilty, but they're saying that the prosecution has enough to convict them, enough evidence to convict them, so they will not fight it. So it is still a type of guilty plea, but without actually admitting guilt. Number 17, personal recognizance. This is E. A bond in which a defendant is released without having to pay money. So somebody is released before trial without actually having to pay bail. 18, plea bargain is J. A contract between a prosecutor and defendant. So this is when somebody is pleading guilty. They are going to enter a plea bargain. They're going to sit down with a prosecutor and with their own attorney. They will write out what that looks like in terms of punishment, and then it will be submitted to a judge to accept or reject that plea bargain. Number 19, preliminary, is O. A screening process used by half the states to determine whether there is sufficient evidence to hold for trial defendants charged with felonies. So this is basically the counterpart of a grand jury, and we'll talk more about that. And then pretrial motion is F. A formal request to the court to make a ruling. So there are lots of pretrial motions that we'll talk more about, but that's the introduction to it there. If you have any questions, please let me know. Our office hours are switching from Google Meet to Zoom. There's more information about that on campus. There's also more information about that in our morning message, so please let me know if you have any questions. Drop by my office hours, send me an email, send me an on-campus message. But that's what the deal is for today. Just wanted to go over this with you. We'll get into some more notes moving forward. But please let me know if you have any questions, and I will talk to you tomorrow.